Virginia.
Yes, ma'am.
All right, thank you. You can have a seat. This is cause numbers 25 DCCR 0838 0839, and then there's 21 37809. And you guys are just gonna have to bear with me. I woke up with this, so I didn't smoke 12 packs of cigarettes. I just sound like I did. All right. Mr. Fletcher was previously in court, entered pleas of not true in a motion to revoke probation in the 21 cause number on probation in that case for the second-degree felony offense of possession of a controlled substance. And the allegations, give me just a second. Okay. Counts 1 through 5 were all pleas of not true. And then I'm just going to try to look back. Were there any pleas of true to any counts, or was that all of the counts in the motion? Is what I'm looking at. Does anybody know? Do y'all recall?
Did he pled true to any of the counts?
It was,
That's right.
those are the only, there were 5 counts.
Yes, Judge.
I'm going to double check that too. And so we've got count 1 was the new offense of manslaughter. Count 2, offense of criminally negligent homicide. Count 3 was aggravated assault with a deadly weapon. Count 4, possession of marijuana. And then count 5 was unlawful carrying a weapon. And all of those, well, not all of them. We've got the first 3 stem from the same date of September 18th of 2024. And then counts 4 and 5 are from July 4th of 2023. And so we're set for a hearing today on the motion. And then once we get through this motion and do today, we'll figure out what to do with the new offenses. But we're going to go on that motion first. I've gotten the updated report from probation. Have you both had an opportunity to review that report?
I have a copy of the update.
It should have been emailed to you, but I can
Stay at the college.
Oh, it sure was. On 1/6, is that what you open? Oh, that's a Johnny's report. I don't have an updated report.
it was some time ago. It looks like the day of the report was actually October 24th of 2025.
Yeah.
November 24th. Looks like November 24th.
Date of sentencing was supposed to be November 24th. We were set initially then and then reset it for a special hearing to today, so for witnesses.
I'm sorry.
You're good. So
I don't think I got that.
Okay.
Returns.
It's. Can you just come make a copy of mine if you can't find it, please? Okay, thanks. I'll let you take a look at mine, and Miss Warner's going to bring one for you. And there's a letter attached also that was I've made part of it. I thought you found it. Yeah.
Is that the rest of yours?
Mhm.
It's going to be from the very back. That's what's. I'm not sure. There you go.
Mr. Guards, there it is.
Either we have a change of lawyer at some point.
Maybe so. I think that could be it as well.
I'm sorry.
No, it's totally fine. I'm just not seeing it. So here we.
Okay. Yeah, it's short. I don't think there's anything. It's yours.
Oh,
All right, and so is state ready to proceed?
State's ready, Judge.
Defense ready?
I can be ready. Obviously, I have an objection, shockingly. I want to object at this time, Judge, to a couple of things. One is, I anticipate the state is going to essentially put on a miniature trial for these alleged new offenses that he currently has a trial setting for, is my understanding. And we, essentially by doing it this way, the state is accomplishing two goals that we object to. And one is converting him into a convicted felon for the purposes, arguably converting him into a convicted felon for the purposes of an actual trial for which he is presumed innocent. And we want our day in court with a jury. And then secondly, Judge, I object to the nature of how the state has pled this as both a manslaughter and a negligent homicide, because and then an aggravated assault. All three essentially. What this is a car accident case involving a death, certainly, but the way that it is formulated here, it makes it appear that there's multiple deaths for starters, and second, again, our concern, our objection is that we believe those types of offenses, particularly in this case where there's not an aggravating factor of intoxication or something else about these offenses, that ought to be properly placed in front of a jury. And no offense to this court, obviously I have great relationship and trust in this court, but for his purposes and for his rights, we believe that this ought to properly, those offenses anyway, ought to properly be in front of a jury. And so we're asking for that. That's what I was hired to do, is to present this case to a jury or defend this case in front of a jury. And so we object to the nature of the proceeding here with this type of offense.
So let me just, before Mr. Coleman, there's nothing legally that prevents us from doing it this way. We've obviously, some cases we do this way, some cases we allow the cases to go to trial first and then the motion. So
Not saying it's a perfect objection, Judge.
okay, I just want to make sure there's no legal prohibition from doing it this way.
I mean, I'm concerned about, again, obviously, if we went to a jury, Mr. Coleman would be welcome to ask for a lesser included of negligent homicide from the manslaughter indictment, et cetera.
So the indictments, I don't disagree that the indictments that have been handed down by the grand jury are for an aggravated assault with a deadly weapon and a manslaughter. There is not an indictment for a criminally negligent homicide. I can and have in a motion and a hearing found true a lesser offense. But what I don't think would be fair is for me to be asked to find true both of those offenses, making it look like there were two separate offenses. And so we can handle that a couple of different ways, but it would look like if I were to find count one and count two, I think they're count one and count two, sorry. Yeah, count one and count two are in essence the same offense, just one a lesser offense of the other. So I don't think that's fair and would agree with that. But what I can do, I guess, is if in fact I find either of them true, it would only be one. And then the other I would find not true if I found one true at all. Does that make sense?
Yes, Judge.
Okay.
Understood.
Okay. So wouldn't want argument, obviously, that they're both true. The aggravated assault with a deadly weapon, is that a different complaining witness?
Yeah, definitely.
Okay, so that makes sense to have the separate one to me.
Yes, Judge.
Okay.
The other component is, Judge, in the indictment, again, this is part of the stickiness of doing it this way. What the state has alleged in their motion to revoke probation is essentially that he committed this offense of manslaughter, of negligent homicide, and of aggravated assault. The problem is, under the statute 21.15, the state is required to prove with specificity or plead with specificity what it is the nature of the recklessness or the nature of the negligence. And it's my position that certainly the motion to revoke probation does not plead those things with specificity. And so it just makes the conclusory statement. Again, this isn't a possession of cocaine case or something where it's just obvious that what the elements are. Here, there 21.15 requires proper notice of what the nature of the recklessness and or negligence is in any reckless or negligence case. And that's not done here.
Well, the indictment reads, did then and there recklessly cause the death of an individual in the manslaughter one. And then it goes forward to say, by operating a motor vehicle, driving 72 miles per hour in a 30-mile-per-hour zone in a residential area at night, and by striking the vehicle. Is that not?
In the indictment, it does, but we're not pleading to the indictment here. I'm not trying to be overly difficult. I'm just being my normal difficult self. But to me, it's a problem because the motion to revoke probation that he's pleading to doesn't plead those elements with specificity.
So based on what I would say, based on obviously the nature of what the indictments allege, the level of proof obviously isn't the same, but I would anticipate and expect, if I'm to find anything true, that the elements, every element of the offense as alleged in the indictment is proven by preponderance of the evidence, not just some random, the elements are the elements. I'm assuming that's what the testimony is going to be.
And on that, Judge, Your Honor, I agree. The elements are the elements. What I don't want to be is hamstrung or tied to the indictment in a motion to revoke probation.
Well, I think it's only fair that the elements of, the motion alleges manslaughter. So it's just, the law says manslaughter is, and in this case, the indictment says it's what it is. And so you're going to prove what the facts of this case are, you would allegedly. So there's no.
I just want to get out in front of any technical argument that Mr. Gertz may make about at the end of the conclusion of the presentation of the evidence and the motion to revoke probation context, that for whatever technical reason we didn't prove up something alleged in the indictment. That's kind of what I'm trying to head off.
So it's obviously a relaxed standard, but I don't see how anyone who's going to come, law enforcement especially, or whatever the allegation is what the allegation is. So I would expect that the allegation, pretty much as alleged in the indictment, is what the facts would be. It's just a different level of proof. Okay? Does that make sense?
So then, just to be clear, and again, I don't think he has to prove each of the manner and means of recklessness. I'm just complaining about the notice in the motion to revoke probation. So the
okay, but you have the indictments, and so you know what the notice is. There's no surprise here.
I'm just making sure that's what he's relying on. Okay. Thank you.
Okay. All right. Anything else before we get started?
Not from the state. Before we begin, I just asked the court to take judicial notice of the entire file, including the conditions of court.
Any objection to that? I'll take judicial notice of the court's file.
Thank you.
Thank you. All right. Then any type of opening, Mr. Coleman, you may call your first witness.
No opening. State waives its opening at this time. The state calls Miranda Beza.
Good morning, ma'am.
Good morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may have a seat. And if you'll just pull that microphone down, make sure you speak loudly and clearly so we can all hear you, okay?
Yes.
Thank you. You may proceed.
Thank you, Your Honor. Would you please state your full name and bullet order?
Miranda Baeza
Baeza. I'll try to pronounce it correctly. How are you employed, Ms. Baeza?
with the Jefferson County Adult Probation Office.
And does part of your duties include supervising individuals who are placed on felony probation?
Correct.
And did you have or have you had an occasion to supervise an individual by the name of Larry Glenn Fletcher Jr.?
Yes, sir.
Do you see Larry Glenn Fletcher Jr. in the courtroom here today?
Yes, sir.
Would you please point to him and identify him by the article of clothing that he's wearing?
He's to my right in the tan clothing.
All right, that's it. The record reflect that the witness is identified the defendant.
The record will so reflect.
And just for technical reasons, do you have a date of birth listed for him in your records?
I do.
What is that date of birth?
December 12th, 1992.
He's on a second degree felony probation for what offense?
Possession of a controlled substance.
And what is the length of that probation?
5 years.
And when did he go on that probation?
He was granted probation October 11th of 2021.
Now, you have not been his probation officer for the entire length of his supervision, have you?
Correct.
When did you start supervising this defendant?
March of 2024.
Now, you are, however, familiar with the process of explaining the conditions of probation to each and every probationer, correct?
Correct.
Do you have any reason to believe that that process was not followed with this defendant?
I do not.
Do you have any reason to believe that he did not acknowledge those conditions of probation?
I do not.
Do you have any reason to believe that he did not understand those conditions of probation?
I do not.
And final question is, what is condition number 1 of his probation?
Do not commit any new offense.
And let's be a little bit more specific. Any offense against the laws of the state of Texas or any other state or United States, is that correct?
Correct.
I'll pass the restriction.
Thank you. Mr. Kurtz?
Mr. Fletcher's term of probation was set to expire in October of this year, is that right?
Correct.
And I understand a motion to revoke his probation was filed in July of 2025, is that right?
Correct.
He's continued to be on bond and now probation since that time, is that right?
Correct.
And supervised by you
Correct.
and compliant?
Correct.
And you didn't have any trouble communicating with him, did you?
Yes, sir.
He was polite with you when he would meet with you, visit with you, etc.
Yes, sir.
And he was generally compliant with the terms and conditions of his probation. You agree with that?
Correct.
I know he had some issues with marijuana during his time on your probation, but setting aside the new offenses, he was generally a compliant probationer. Do you agree with that?
Yes, sir.
Ask what, Judge.
No further questions from Ms. Baez. Let me should be excused, Judge.
Any objection?
No, Judge.
Thank you, ma'am. You're excused. You may call your next witness.
The state calls Officer Jeffrey Busby.
Officer Busby. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can have a seat. And Detective, if you'll just kind of pull that microphone close so we can all hear you. Thank you.
Please state your full name for the court reporter.
Jeffrey Busby.
And could you help me with the rank? I referred to you earlier as the officer. Is it actually detective?
I'm a detective.
I apologize. Detective Busby, how are you employed, sir?
I'm employed with the City of Beaumont Police Department
How long have you been with BPD?
since 2014, so over 11 years.
Very good. I'm sure the court's familiar with you and your background and training. I'm not going to spend any time on that, but I will ask you, back in July, specifically on July the 4th of 2023, as part of your duties, what, if anything, caught your attention at around 7:07 p.m.?
So on that particular day, Sergeant Pratt and I were operating as a two-man unit, and we're patrolling. I observed a vehicle with a tinted front windshield that caught my eye in the area of East Tech Service Road and Lucas. And that being clear violation, that's what caught my attention. So eventually I conducted a traffic stop on that vehicle.
East Lucas and East Tech Freeway, that's in the city of Beaumont in Jefferson County, Texas, correct?
Yes,
Once it caught your attention, what, if anything, did you do next?
So it was at the intersection. It was going to indicate a turn onto Lucas. I waited for it to make its turn. And then from there, I got behind it and activated my lights to initiate a traffic stop. And we came to a stop in the Home Depot parking lot, which is the 4200 block of East Lucas.
And I'm assuming you made contact with the operator of that vehicle?
Yes, sir.
And when you made contact with that operator of the vehicle, was the operator of the vehicle the sole occupant of the vehicle?
Yes, sir.
And what, if anything, did you observe or experience?
So as I was approaching the vehicle, the tent was excessively dark on the sides also, so I called out to the driver to roll all the windows down so I could see inside the vehicle as far as for safety. And then once I made contact with him, I immediately smelled the strong odor of marijuana coming from the vehicle.
And are you familiar with the distinct odor of marijuana through your training and experience?
Yes, sir.
And the driver, the sole occupant of the vehicle, was he identified?
Yes, sir.
And who was he identified to be?
So Larry Fletcher Jr.
Larry Glenn Fletcher Jr.?
Yes, sir.
Do you see the individual identified that day as Larry Glenn Fletcher Jr. in the courtroom?
Yes, sir.
Would you please point to him and identify him by an article of clothing that he's wearing?
Here in a light tan color polo.
As the record reflects, the witnesses identified the defendant.
The record will so reflect.
What did you do next?
So after I made contact, smelled the odor of marijuana, asked for his ID. His ID was above his sun visor around that area, so he handed it to me. And then as I was briefly speaking with him and smelling marijuana, I went ahead and had him exit the vehicle.
Okay. And what, if anything, did he admit to you after exiting the vehicle?
So as either right before he exit or as he's exiting, asking has he weapons in the vehicle, he says no. As he exits, we're getting to the car, asking is any marijuana, any weed in the car, he says yes, that he does.
Okay. And in addition to you smelling the distinct odor of marijuana, the defendant has now admitted that there's marijuana in the vehicle. And did you obtain consent to search the vehicle?
I did. I asked if I could search his vehicle, and he said I could. I had probable cause already, but he also gave me consent.
That was my next question, is whether or not you even needed consent.
Yes, sir.
All right. So you conducted the search of the vehicle. What, if anything, did you find?
So I first checked where he was sitting at, which is around the driver's seat. Underneath the seat, I saw a black handgun. When I looked under the seat, the handgun was pointing at me, so the barrel was facing towards kind of the gas pedals. That kind of caught my attention, and behind it, I could also see a small container. The silhouette, it looked like large marijuana buds. So after I seen the firearm, I went and placed him in handcuffs because he originally said he didn't have a firearm. Now he does. That really brought my suspicion up on why he would lie.
Anything else was in addition to the firearm and the marijuana in the front seat? Anything else that was found in the vehicle?
Yes, sir. After I placed him in handcuffs and got him secured, I continued my search and found a Nike black backpack. It was white and black in the back passenger seat area, and that contained a larger amount of marijuana.
What, if anything, was tell the court how the marijuana in the backpack was packaged?
So it was originally this vacuum sealed bags, and the bags looked like they were in 1 pound increments, but that wasn't the total weight. It was going to probably be around 1 to 2 ounces in each bag, but the bag itself is 1 pound bags vacuum sealed. And also inside the backpack was a functioning digital scale. Anytime I see a scale, I'll see if it's functioning to make sure that it is true, because if you have a functioning scale, it means that they're more likely using it regularly.
Okay. And based on your training and experience, where you've got individually wrapped baggies of marijuana, you've got a firearm, you've got a digital scale, based on your training and experience, what is that typically indicative of?
For me, it's you're either a narcotics trafficker or you're a high-end buyer.
And in addition to the defendant admitting that there was marijuana in the vehicle, based on your training and experience, are you familiar with the appearance of marijuana?
Yes, sir. During this period of time, I was a narcotics detective. I have many years' experience leading up to this, but this particular time I was assigned to narcotics as a detective.
And this substance that he identified as marijuana was consistent. Is it your testimony is consistent with the appearance that you know to be marijuana?
Yes, sir.
Based on all of those things, did you form an opinion as to what, if any, laws this defendant had violated?
Yes, sir. Other than the traffic violations, placed him under arrest for possession of marijuana and the UCW.
Possession of marijuana in violation of Controlled Substance Act, Section 481.121,
Yes, sir.
and a UCW, unlawful carrying of a weapon in violation of section 46.02 of the penal code.
Yes, sir.
What made that a UCW? How did you get there?
So whenever you have a UCW charge can reach in a few different ways. For this, he has committed another offense other than traffic. So with the marijuana, it was going to be a minimum of a Class D misdemeanor. So that gives you the UCW.
Very good. Were you outfitted with any recording device or devices that day?
Yes, sir, I was.
That would be in the form of a body-worn camera, correct?
Yes, sir.
As far as you know, was that body-worn camera properly operating that day?
Yes, sir.
You, as the operator of that body-worn camera, is certainly capable of properly operating it, right?
Yes, sir.
Was this encounter between you and the defendant captured on your body-worn camera?
Yes, sir.
May I pursue with the search?
Yes, sir.
Detective Busby, I am showing you what I am marking as State's Exhibit number 1. For the record, what type of a device are we looking at here?
It's a USB thumb drive.
Do you recognize that USB drive?
Yes, sir, I do.
How do you recognize that USB drive?
So I have a piece of paper, my initials and the date that I've observed this and observed the recording on there.
And what date was that?
It's today.
Just before you testified?
Yes, sir.
You're on time state on stage 1. Well, and the contents of this video, are they true and accurate with no alterations and deletions as far as you?
Yes, sir.
Stage 1 judge, tenured to defense counsel for his inspection. I might add, it was also provided to defense counsel discovery.
Judge, we have no objection to the video itself.
So stage 1, no objection.
Stage 1, no.
Okay, it's admitted.
And let me be clear, Judge, if this were a trial, we might be having a motion to suppress hearing about the 10th issue. Obviously, I'm going to argue that later. So I'm not objecting because the court gets to look at everything anyway.
Sure.
So I'm doing that strategically so we don't sit here and waste time to that.
Thank you.
Just so the record is clear that I'm aware of that problem and we'll address it at the appropriate time.
Thank you. All right, it's admitted.
Thank you, Commissioner Bowles, Judge.
Yes, sir.
Roy went down there. The lawyer went down. Thank you. Do the other side too?
Detailing your involvement in this case.
Yes, sir, I did.
Did you do it at or near the time when these events were still fresh in your mind?
Yes, sir.
Did you review it prior to testifying here today?
Yes, sir.
No further questions. I pass it with the judge.
Thank you, Mr. Coleman. Mr. Kurtz.
Detective, do you have some kind of instrument that you use to test out whether someone's temp is over the 25% level or not?
Yes, sir, I do.
Okay. I noticed that you immediately had him, Mr. Fletcher, roll down each of his windows.
Mhm.
I also noticed, at least in what I saw here, that you did not use that instrument on his vehicle. Is that correct?
That's correct.
The Texas Transportation Code lays out the percentage that you're allowed to have or not have of tint in terms of the amount of light that can get through. Is that correct?
That's correct.
When you observed him driving the vehicle before you initiated a traffic stop, were you next to him or were you passing him?
It would have more likely been passing him.
You don't recall?
Well, I don't recall because I don't see on the video, but I recall the day. And whenever me and Sergeant Pratt were working, we were in the north end and we were going towards the west end because that's kind of the typical path I take. And Mr. Fletcher would have been on the service road to my right as we passed, and that would have caught my eye because working interdiction, illegal front windshield, like the 10 on the front windshield catches my eye, something that I look for. And that would have caught my eye, so I would have turned around and waited for him to get his green light so I can get behind him and conduct my stop. So I believe on this particular stop, his registration was cut out around the tent. So you could see the difference between the registration having no obstruction and the tent itself on the front windshield.
Okay. But so your testimony is that he's not allowed to have any tent on the front windshield.
As long as it's not below the AS1 line, approximately 3 to 4 inches from the top of your windshield, there's an AS1 line that's indicated.
Yes, sir.
Now, if you get an aftermarket windshield, it might not have that AS1 line there, but you can't have tint below that AS1 line unless you have some type of disability and you have a letter saying you have this from a doctor.
Did you, each of the, when someone puts tint on windows and windshields, etc., they're required to have a certification sticker on there, are they not?
They should, but not everybody puts those certification stickers on there.
Sure. But did you observe whether or not these had any kind of certification on them or not?
No, sir, and I wouldn't, because of my questioning, I might not have looked at that because he says he buys the vehicle like that. Because if he'd have said, I put it on there, my follow-up would have been, well, do you have a medical reason? Giving him a reason for this.
Did you ask him when he bought the vehicle?
I did not.
Did you ask him how long he'd owned the vehicle?
Not that I can recall.
Okay. Judge, if that's what I assume.
All right, thank you.
I have no further questions for Detective Busby.
Any objection to Detective Busby being excused?
No, Judge.
No, Judge.
Thank you, Detective, you're excused.
Thank you.
You may call your next witness.
This day calls Officer Gabriel Fales.
Felds.
Fales, Fells.
Thank you. Good morning, sir.
Morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat. I'm gonna just kind of move that microphone over a little bit so we can all hear you. Thank you, sir. You may proceed.
Thank you, Your Honor. Good morning. Would you please state your full name for the court reporter?
Officer Gabriel Fells.
And Officer Fales, if I can get you to speak up a little louder, I want to make sure that everybody has a chance, especially the judge, to hear you. How are you employed, Officer Fales?
How am I employed?
Yes, what do you do for a living?
I'm a police officer in the city of Beaumont.
How long have you been with BPD?
8 years.
And your duties, what do they include?
Patrol. So
And this is exactly why courtroom hearings like this matter. What started as a probation review quickly turned into a deep examination of evidence, legal strategy, and the consequences of every decision made long before trial. Remember, a motion to revoke probation doesn't require the same level of proof as a criminal trial, but the outcome can still completely change a defendant's future. Whether you believe the prosecution built a strong case or think the defense raised valid concerns about fairness and due process, one thing is certain. Every word, every objection, and every piece of evidence can influence the final ruling. So, what do you think? Should the judge revoke Larry Fletcher's probation based on the evidence presented so far? Or should these allegations be left for a jury to decide first? Let us know your opinion in the comments below. If you enjoy detailed courtroom breakdowns and real legal analysis, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss the next case.